This video has been produced by the UFU about bargaining for the 2024 ACT Fire and Rescue Enterprise Agreement, and the purpose of the video is to respond to the bargaining claims that have been made by 4 self-appointed bargaining representatives. Those representatives are Greg Abrahamsky, Robbie Thompson, Andrew Steele and Greg Mason. This is not the first time that someone has appointed themselves as a bargaining representative in bargaining for an agreement under the Fair Work Act. There were negotiations between 2018 and 2020 which were the subject of a lot of media coverage. A person appointed themselves as a bargaining representative for those negotiations, and his name was Matthew Mavity. He, at the time, was a commander in fire and rescue. Problem was, we didn't know that he'd appointed himself until the 29th of June 2020, when an application was made to approve the enterprise agreement after it had been negotiated, after it had been agreed, after it had been voted on. So I guess the situation has advanced in one respect this time, that at least the self-appointed bargaining representatives have shown up. So for the purposes of this video, we've grouped the claims together in categories that relate to the response that we're giving. And the first part is about matters that are not currently covered by the agreement. This relates to the claims GA4, 6, 7, 15, 18 and 20, and claim RT14. These are about annual leave numbers going in the agreement, looking at billing insurance companies for standby operations, looking at setting up billing for other agencies, being trained in particular locations around CAFs, maximum time on specialist appliances, changes in the way that overtime is allocated, and policy and development to be undertaken during the life of the agreement. None of these things are presently covered by the agreement, and in circumstances where the self-appointed reps are wanting to have fewer things in the agreement, we don't see why these things should be added. So for that purpose, our response to those claims is that we are not accepting them. This next part of the video is about misconceived claims. These are claims which have just got it wrong, and this relates to claims AS4, 7 and RT4, 17, 3, 6, 7 and 15. To go through them briefly, the first seeks to retain some words but are not limited to in the enterprise agreement. This is misconceived because you just don't make a claim to keep existing wording. It's already there, no one is suggesting it changed, so there's no need to even make that claim. The second one is about providing that you don't have to become unattached to access leave in transition to retirement. Well, that's a bit the same, because the factual position is you don't have to be unattached to access leave in transition to retirement. There is not, nor could there be any such requirement, because it would offend the National Employment Standards in the Fair Work Act and it would offend the agreement. So that one falls over as well. There is a claim to put freedom of association and respectful behaviours in the agreement. This is misconceived because clause P4 of the agreement already provides that employees can choose who they're represented by, can't be discriminated against, and engaging in negotiations of any time they can have their representative of choice. It's already in the agreement, no need to put it there twice. The next one is to claim that previous experience and qualifications are relevant for the purposes of transfer in a position where you're redundant. We really don't need to address this because the enterprise agreement already has a provision at clause S 4.2 that you can't be made redundant in the life of the agreement. In addition, where this relates to ill health, it's a core employment provision of the ACT government, and the government's unlikely to depart from the core. The next claim that's ill-conceived is that it says that Section A of the agreement is too complex. But Section A deals with the technical matters, and technical matters are complex. They're things that are there because of the Fair Work Act content rules. You can see those in front of you now. They include that it must describe the employees, it must say who's covered by the agreement, it has technical matters about the national employment standards applying, it has to be signed and dated, it has to have mandatory terms. All of these things come from the Fair Work Act. And so you simply can't make it less complex than the law already provides. Then there are 3 other proposals to simplify the agreement or conduct staff development prior to selection and promotional processes, and another one that asks what fitness evaluations are conducted against. Well, those 3 proposals are not clear, and without additional detail, we can't give them proper consideration, and there's simply not time to do that. So all of those claims are similarly not agreed by us. This part of the video is about agreement compliance issues. That is, it's about non-compliance with the current enterprise agreement rather than a claim to change what's in the agreement for the next agreement. It's unsurprising that some of these have come out through the course of negotiation. There has in fact been a culture of lawlessness in recent years around the application of the enterprise agreement in ACT Fire and Rescue. We've taken the employer to court 4 times successfully, and we'll talk more about that in another video. That's not for today. But one of the problems is that there are statements often made that the agreement is an aspirational document, and if you're trying to apply it, then that's good enough. No. To quote someone else, there is no try, there is only do or not do. The agreement has the force of law. And so the claim about recreation leave being approved up to 4 hours is actually about agreement compliance. There is a 4-hour limit in fire and rescue policy, but we say that conflicts with the agreement, and it shouldn't be in the policy because it misrepresents a workplace right. The issue of meal allowances and their application to overtime shifts is also in the agreement. We say that's a compliance issue. The issue of paying overtime from recall of duty, from the time of the call instead of when you arrive at the station, that's an agreement compliance issue as well, and that's been custom and practice until it was changed only very recently. To fix this, we've drafted a clause which we think will be readily agreed so that it puts this issue beyond doubt. The next one is about station officer numbers on operations. Again, that's an agreement compliance issue because approval of leave is not contingent on the availability of spare or relieving staff. There is a scheme in the agreement for filling of temporary vacancies, and that's what should be applied. And the final one is the claim that Annex E is out of date. Again, that's an agreement compliance issue, particularly around the awarding of a diploma for commanders. If this claim, though, is to update Annex E, we agree with it, and we've put a claim in to do just that. So all of those agreement compliance issues can be addressed in another way. Part 4 of this video is about claims made by the self-appointed representatives where the UFU had already put a claim on in relation to the same subject matter. This covers claims GA 12, 13, 14 and 17. And broadly what they're about are increasing ComSen staff, investigating a senior firefighter role in ComSen, annualisation of a number of allowances, and pausing recruitment until closer to when Molonglo Fire Station is built. In relation to all 4 of those claims, the UFU already has claims on the bargaining table and will be pursuing our claims. Part 5 of the video is about claims that would result in loss of entitlements. The irony here is that one of these claims is put forward by RT to claim that there should be no loss of entitlements. But then that same person goes through and makes a number of claims that would result in lost entitlements, and they're serious. The first one is RT claim number 20, which seeks to align the leave entitlements with the Fair Work Act. Now you can see in front of you that there are 7 that are covered by the Fair Work Act. And they are personal, compassionate, annual, long service leave, parental leave, leave for family violence and community service leave. There's a matter on the cusp which is about concurrency care entitlement for adoption leave. But then that's where it ends. So if you aligned our leave entitlements with the Fair Work Act, you'd only end up with those 8 entitlements. What it means is that there are a further 24 types of leave that are paid and a further 10 types of leave that are unpaid, that if you aligned with the minimum entitlement of the Fair Work Act, you would lose them all. And on top of that, you would lose workers' compensation make-up pay, because that is in the agreement as a form of leave. We simply can't agree with this. And on the one hand, this bargaining representative is saying no loss of claims or no loss of entitlements, but they're saying align it with the Fair Work Act, and the effect of that would be to do exactly what they say they don't want to do. These claims are being rejected outright by us because our members would lose conditions. There's a further claim, which is RT number 11, and it seeks to adopt or align with Public Sector Management Act standards and provide the same entitlements for all ACT government employees. That's claim RT 11. That is addressed in our attempt to adapt the core conditions to fire and rescue, because there are fire and rescue specific terms. There are 8 of those, and if you aligned in the way that this bargainer wants us to, casual firefighters would open the door to retained or auxiliary firefighters. There'd be a reduced entitlement and safeguards for transfer to a safe job during pregnancy. The consultation clause would be undermined. You could be directed to work outside of normal hours instead of our system of rosters and offer and acceptance of overtime. It would change the way entry to fire and rescue happens. It would change the way that advancement and promotions happen. It would change the merit lifespan back to a year, and it would change conditions relating to promotion. Obviously, we can't agree to this. This would result in our members losing conditions. So that claim number RT11, is not agreed either. So I mentioned a little while ago that we might lose accident compensation make-up pay. Members who've been around a while will remember that, because with the last round of negotiations in 2018, the employer offered us a 10% pay rise over and above the core increases to take away 5 key areas of conditions, and they were to remove accident compensation make-up pay, to remove the requirement to agree with the UFU, to change recruitment processes, to have mandatory fitness assessments and mandatory drug and alcohol testing. And guess what? Claims RT16, RT19, RT18 are all consistent with that, and there is even a claim to remove the time frame for merit lists, which is also related to the claims of the employer in 2018. All of those claims were rejected by our membership, and they are rejected again by us. You can't even call this a sellout, because there's no money attached to it at all. This particular bargaining representative is offering these conditions up for nothing. So, in relation to loss of entitlements, claims RT1, 20, 11, 16, 19, 18 and 8 are rejected. There are a number of claims which should be dealt with in the life of the agreement because we're simply not going to have time to conclude everything. And these are claims RT 23, 21 and GA 8. The first two deal with driving instructor allowance and ADF leave. We think these are items that should be dealt with in the life of the agreement, and the first one of those is in the leave reserved clause that we've drafted. The next one is about upgrading the pumper at Gungahlin to a rescue resource to be stationed at Gungahlin Station. We think this can be pursued during the life of the agreement, and a good place to start is the Vehicle and Equipment Committee, which has union and employee representation. This part of the video deals with claims that are related to work value matters. Work value is complex. It was dealt with by the Industrial Relations Commission in 2006, some 18 years ago, and it took a couple of years to get that case on foot and run it. The claims that have been made by the bargaining representatives are GA16, GA22, AS11 and RT5. 3 of these claims seek to introduce pay increments. Pay increments were removed from the award and consequently the enterprise agreement by the work value decision in 2006. At paragraph 146, that decision says, the application in this matter seeks to delete in its entirety the current 14-level classification structure together with the descriptors of those classifications and replace them with a simpler broad-banded 8-level structure. That involved the setting of relativities, and the relativities result in your level of pay. And when the increments were abolished, the Commissioner identified this. They said, I do not accept that it's appropriate in all cases to merely adopt the highest, or for that matter the lowest relativity that is applicable where a number of classifications are broadband into a new classification. So what in fact happened was the increments were absorbed and the overwhelming number of people on those increments got a pay rise. The Commission went on to say at paragraph 158, having proposed the collapsing of 4 levels of station officer into one FB6 level, the parties disagree as to the relativity that should attach to that level. So the Commission decided that at the highest level of station officer, the relativity is 18%. In my view, the single level station officer salary should be 16% higher than the FB5 level. So in other words, station officers, the majority of them, got a pay increase as well. As well as that, allowances were caught up in the work value decision. And the Commission said they had regard to the comparison chart of allowances under the industrial instrument that apply to brigades in other jurisdictions, and noted the fire brigade submission that the comparisons must be read in light of the higher base rate that applies in the ACT. So if you start undoing the work value case of 2006, you start undoing the relationship between allowances and the pay rates at each level. If you're going to address work value, you don't address work value by going backwards. And it would be a backwards step to undo those matters from the 2006 decision. We will deal with work value in the life of the agreement, but we won't deal with it in the way that these claims suggest. A further claim that relates to work value is GM2, and that is in effect to introduce brevet ranks, which would enable staff to fill a higher classification where it couldn't be filled by someone at that level. We're taking this discussion very seriously, and we've asked for the government to produce us with a paper about how this complies with the merit principle. When we receive that paper, we will respond to this claim. This part of the video deals with proposals to deregulate crewing. Crewing is addressed in Schedule 1 of the agreement. And Schedule 1 sets out where the appliances with firefighters are required, and it lists them by fire station. Both of these proposals, GM1 and GA3, seek to change Schedule 1 so that it no longer says where the firefighting resources are. And in turn, it would mean that they could be moved around with consultation with us. Well, the problem with that is that if you don't specify where they are and where the firefighters are, it opens up to some very dangerous situations, and I'll explain that in a moment. Now, back to the bargaining representative I mentioned earlier, who didn't show up in the negotiations. He had a lot of knowledge because he was going to be provided with all the documents in the negotiations, and I understand he in fact was. He later became the chief officer. And when he became the chief officer, he became very critical of the enterprise agreement. By way of background, there's a thing called the ACT Labor Advisory Council, and that is where elected members of the Labor Party meet twice a year with representatives of the trade union movement. At one such meeting on the 28th of July 2023, the first meeting post-COVID, I was able to thank the Minister and the Chief Minister for their commitment to increased crewing in the enterprise agreement and point out to them that the centrepiece of that commitment is Schedule 1 of the agreement. I also pointed out to them what many of our members had told us that the Chief Officer had been saying, and that was, quote, "The enterprise agreement is a shit-fight, low-trust document that's poorly thought out and those who signed it should be ashamed," unquote. The Chief Minister was wide-eyed. His jaw was still on the table, literally, when the Minister piped up and said, "I don't support removal of the crewing chart." The Chief Minister followed suit. The government members present were unanimous in their view, and they made clear to all the representatives of the union movement that they wouldn't be supporting the removal of Schedule 1 either. It follows that they wouldn't support the gutting of Schedule 1 in the way that these claims propose to. Now, I said it might lead to a dangerous situation. The dangerous situation is this. Have a look at Section 52 of the Emergencies Act 2004. And what it says is that the Rural Fire Service may respond to a fire in built-up areas and provide first response to any other incident to which another emergency service may respond under the Act if the emergency service is unavailable. In short, if fire and rescue are not at the fire stations, the Rural Fire Service can station themselves there and take over work in the built-up area. That's been in the Emergencies Act for a number of years, and it relates to a very dangerous initiative called the Strategic Reform Agenda, which I'll talk about a bit more later. In addition, every time that fire and rescue has wanted or needed to move an appliance, the UFU has agreed with them. So we are not going to agree to amendments to Schedule 1, particularly in circumstances where the Chief Minister and the Minister have stated in front of their caucus and in front of the union movement that they support its retention. The next part of this video deals with proposals to provide deregulation around 24-hour shifts, that is, to make 24-hour shifts more prevalent. These are claim numbers GA19, 21 and AS 8 and 9. Now, to look at this, the starting point is work health safety. Every government and every workplace is covered by work health safety laws. Now, there are some other fire services which have 24-hour shifts, most notably in New South Wales, where they were implemented in 2015. In 2012, ACT Fire and Rescue conducted a trial of 24-hour shifts, and we'll talk about that in a little while. But the state of knowledge about work health safety changes. And as you can see from the definition of reasonably practical in front of you, it includes what the person knows or ought reasonably know about the hazard or risk and the way of eliminating or minimising the hazard of risk. It also includes the degree of harm and the availability and suitability of ways to eliminate or minimise the risk. There is a hierarchy of control in work health safety which sets the order in which risks should be managed. Here's some guidance material from WorkSafe Victoria that deals with it, and we've set the control measures most relevant to 24-hour shifts out in this, and you'll see there towards the bottom, you can't eliminate the hazard of fatigue. You can't reduce it with substitution or isolate it or isolate people from it or engineer controls. You can engineer changes to systems of work, which would be a way of getting rid of 24-hour shifts where they're assessed to be a risk. Or you can use administrative actions to minimise exposure. Implementing these clauses to take away the checks and balances aimed at keeping the workplace safe would be to reduce the level of control. So it's against the definition of reasonably practicable, and it's against the hierarchy of controls. We'll now move on to the specific risks associated with these shift patterns. So to pick up the theme of the state of knowledge and what we know and what we've come to know since 2012 and 2015, here are some developments that have taken place since 2010. Firefighter presumptive cancer legislation for ACT and aviation firefighters in 2011. Many academic studies, including the Monash study, which is the largest study of firefighter cancer ever undertaken. PFAS has been phased out progressively from 2005, and in January of this year, the World Health Organization classified PFAS as possibly carcinogenic based on strong mechanistic evidence, and classified PFOA as carcinogenic to humans. In 2020, the World Health Organization, International Agency for Research on Cancer, declared night shift probably carcinogenic to humans, the second highest category. In 2022, the same body classified firefighting as carcinogenic to humans, the highest classification. And following that, in December 2022, the Commonwealth Government expanded ACT and aviation firefighter presumptive cancer laws from 12 to 20, including for the first time female reproductive cancers. In 2023, the Tasmanian Government went even further to expand the list to 21, and there is legislation before the Queensland Parliament to follow suit. So that's how quickly the science moves. We've learned an awful lot since 2012 and 2015. When you look at the shift work issue, the World Health Organization looked at what is wrong with shift work, and there's the list. It interrupts the natural cycle of sleep and wakefulness and related patterns of activity, and staying awake at night and trying to sleep during the day is not a physiological condition for creatures like us. And the key characteristics of cancer, or building blocks, are known as mechanistic effects. They include that it increases oxidative stress. It's a bodily condition that arises when your antioxidant levels are low. It suppresses your immune system. It introduces chronic inflammation. It affects your DNA, causing mutations that cause cancer. And it brings about changes to DNA structure. Stress is heavily associated with this, as are many of the exposures that firefighters experience, and COVID, as an inflammatory disease, makes this worse. Add those things up and your cancer risk increases. Shift work, chemicals, stress, diseases like COVID. And the evidence of cancer in firefighting is even stronger. Firefighters face a toxic trilogy that contributes to increasing rates of firefighter cancer, and DNA studies show that in the first 3 years of a firefighter's career, their cancer resilience is reduced by a factor of 1.5. What we also know since 2015 is that the 24-hour roster in New South Wales transitioned very quickly from a trial to being applied almost universally across permanently staffed fire stations. There was a review conducted by Ernst & Young, which I'm referring to now, and these are the comments of Jeremy Futrell in that study. And he says that Fire and Rescue did not anticipate the rapid take-up of the roster, and a number of policies and processes had not been appropriately adjusted to accommodate that rostering format. And significant factors for the long-term sustainability of the organisation have come about, including the lack of connection to the organisation and a lack of motivation to progress to senior roles. Health and safety issues connected to any fire service rostering arrangement and the management of fatigue is chief among the issues in the context of 24-hour shift system. It's there in that report. We'll provide it to you. It's Fire and Rescue's own report. There is a summary of findings which says that they've not implemented adequate policy and guidance to support the consistent implementation of the 24-hour roster. There are opportunities to improve the connection between firefighters, their colleagues and the organisation. The design of the roster presents additional challenges for fatigue risk management and monitoring. Many firefighters are hesitant to engage in career progression. The anticipated benefit of reduced sick leave and improved absence management has not been realised. There's perceived inequality in the application of the roster. There are challenges in delivering core and special skills training, and there's limited transparency and governance for firefighters with secondary and other employment. All of these issues were outlined in the report by Ernst & Young. So here you have an employer who has this system in place, pointing to deep cultural problems with it. Add that to the other issues that the ACT government already know about. For example, in front of you now, you'll see some news about an Ambulance Victoria collision. You can read it for yourself. The government already has. You can also look at the news about a fire and rescue truck crash in Barton while we were negotiating the current enterprise agreement. And guess what? The driver of that truck had come off a 24-hour shift, was towards the end of that shift. Fortunately, the inquest found that it was actually the driver of the other vehicle who was completely at fault, and that the truck had lights and sirens running at the time of the collision. The government was acutely aware of this when we were negotiating the 2020 agreement. So here we have findings which talk in an academic sense. We have findings which talk in a cultural sense, looking at where these rosters have been applied. And then we move right through to very real risks with working long shifts and risks here in the ACT. In the ACT, there was a trial of 24-hour shifts, which was supposed to only go for a few months. Hasn't gone for a few months. It's gone for 12 years. And that's where the wording in the current agreement came from. There's been some conjecture about that wording, and I think the best thing to do in acknowledging the source of that wording is to look at the source documents. And it all starts here with an email of Paul Swain, the then Chief Officer, June 11, 2012, where he says the union have requested that Fire and Rescue modify their stance to allow some flexibility for firefighters who occasionally want to work 24-hour shifts, and said we're not opposed to this and currently working with the union to develop a guideline for commanders. The proposal will allow one 24-hour shift in any 8-day cycle. Fast forward from June 2012, just a short period of time, to August 2012, where the wording that we now see in our enterprise agreement is explained. So what that wording was aimed at was trialling 24-hour shifts for people who occasionally wanted to work them. The trial was never intended to take it further than that. So, as I said, look no further than the source documents. It's a matter of record that our members met in relation to this issue, and yes, there was division, but we operate on the basis of group decision making. We bargain collectively, and the UFU has no proposal to deregulate 24-hour shifts to make them any more accessible or any less accessible. There is, however, a body of information that the employer has at its disposal which has already led them to make a claim to restrict 24-hour shifts. The ESA Commissioner very recently wrote to all fire and rescue staff to indicate that in response to the claims of the self-appointed bargaining representatives, there is a counterclaim, and that is to limit 24-hour shifts to only emergency circumstances arising through overtime that are required to keep trucks on the road. The UFU ACT branch does not support a relaxation of rules around 24-hour shifts. Okay, this part of the video deals with removal of UFU rights, and if you think back a little while, we covered the employer claim in 2018 to offer a pay rise to remove the requirement in the agreement to agree with the UFU. So these claims are AS2 and RT9 and 13, specifically to remove reference to the UFU and to replace joint selection committees with selection advisory committees that don't have UFU representation, and change any references to the UFU to all parties. Now, there's quite a story around why this is a problem. The starting point is the ACT government's union encouragement policy, which you can see right now. And it says that all executives, managers and supervisors should actively cooperate to ensure the public service continues to encourage union membership. And encouragement requires executives, managers and supervisors to adopt a positive and supportive role, not simply passively accepting membership recruitment and representative activity by unions. And that the personal views of executives, managers and supervisors are not to be used to discourage employees from union membership or to neglect to facilitate union membership in the ways provided for in this policy or enterprise agreements. Executives, managers and supervisors are not to directly or indirectly impede legal union activity. Information on relevant unions is to be made available to relevant employees at the point of engagement, including up-to-date membership material, applications forms, details of fees, and general information about the union. And finally, collective industrial relations. The government acknowledges that structured collective industrial relations are to continue as a fundamental principle of management, and that includes rights for employees to negotiate collectively, and the policy reaffirms that commitment. These are duties on managers in fire and rescue, and I would point out that they apply equally whether you are a station officer or a superintendent. Now, what do we mean by relevant unions? What is relevant union in a federal agreement? Well, to answer that question, you need to look at the Fair Work Act, where it deals with coverage of employee organisations. Here's some guidance material from the Fair Work Commission, and it says that an agreement covers a union that was a bargaining representative of employees who will be covered by the agreement. If the union makes application to be covered by the agreement, the Commission will note in the approval decision that it covers the union. And when it covers a union, the union will have certain entitlements that it would otherwise not have. For instance, the union will be able to enforce the terms of the agreement, as we have done. Section 183 of the Act deals with the entitlement of the union to seek to have the agreement cover them. And that includes setting out a notice that we want to be covered, and the notice has to be given to the Commission and to the employer, and the Commission must note in its approval decision that the agreement covers the employee organisation. Not only that, the Act in section 256A explains how employers, employees and employee organisations are to be described. And it says that the employers and employee organisations must be specified by name. And then if you go to the definitions, an organisation means an organisation registered under the Registered Organisations Act, which is federal legislation. There's only one firefighter union registered under federal legislation. That's the United Firefighters Union of Australia. There are a couple of state registered organisations that have sought to distance themselves from the UFU, but as a matter of law, the UFU is their federal counterpart. There is no other federal counterpart. How does that translate into everyday rights in the workplace? Well, one way that you can examine that is to look at the area of right of entry, because being an organisation that is covered by the enterprise agreement gives permit holders from that organisation, like me, the right to enter the workplace. And that's dealt with in section 484 of the Fair Work Act, which says a permit holder may enter premises for the purposes of holding discussions with employees who perform work there, whose industrial interests the permit holder's organisation is entitled to represent, and who wish to participate in those discussions. In respect of firefighters in the ACT, the entitlement to represent industrial interests comes from the UFU rules. There is only one organisation entitled to represent firefighters in the ACT, and that's the UFU. So if you want to remove that, there are a number of legal impediments to it, and, as was suggested by one of the bargainers, including a reference to other fire unions, given the legal position, is simply not possible, because the UFU is the only federally registered organisation that can be covered by a Fair Work instrument. So unsurprisingly, we're not about to go and negotiate an agreement and agree that we should be written out of the narrative. We're here to stay. This part of the video deals with bargaining claims to have individual agreements that would in fact be unlawful. Individual agreements were part of a system called work choices that was introduced by the Howard government. It allowed people to have individual agreements which contracted out of the award or the enterprise agreement. Now, these appeared attractive to some people, but ultimately they were outlawed in 2009. And that's because the experience was that people lost their working conditions. More than 1 million Australians on awards suffered a real pay cut of up to $97 a week at the time because of the way that changes to minimum wages were set under work choices. Hundreds of thousands of workers were pushed onto individual AWA contracts. 70% lost their shift loadings. 68% lost annual leave loadings. 65% lost penalty rates. 49% lost overtime loadings. 25% no longer had public holidays. Not only that, more than 3.5 million Australians lost protection from unfair dismissal, and unknown numbers were sacked or treated unfairly and had no recourse. That's why that government was voted out and these agreements were made unlawful. That was in 2009. One of the key cases of the work choices era was CommSec. You've probably all heard of CommSec, a large securities trader belonging to the Commonwealth Bank. You can see the case reference in front of you now. This was before the federal court, and the judge observed that that proceeding was about a scheme by one of Australia's largest corporations to establish individual and unregulated contracts of employment in part of its business, and their scheme, which is essentially an industrial regulation avoidance scheme, possesses an ingenuity that is reminiscent of the tax avoidance schemes of the 1970s. and the question arising in this proceeding is whether, notwithstanding the ingenuity, the scheme was unlawful. Now, the advantages of Clause 12 agreements under their agreement was, from ComSec's point of view, that they could agree to terms and conditions on an individual basis, that there could be an individual contract rather than a collective agreement, that there'd be flexibility to suit growing businesses. Now, because of that, the agreement was ruled invalid by the federal court. And the reason it was declared invalid was that if you have a collective agreement and there is ability to contract out of the collective agreement, then the Commission can't be satisfied that the agreement passed the no disadvantage test. So thousands of workers lost their enterprise agreement. The whole agreement got blown up by the operation of these Clause 12 agreements in ComSec. The bargaining claims related to this are 7 in total. And this is in 2024, some 19 years later. They are claims GA2, GA5, AS3, 5 and 6 and 10, and RT12. And in short, what these claims want to do is allow individuals to contract out of effectively any clause in the enterprise agreement. That is exactly the same situation that led to the ComSec agreement being overturned. So it follows that the Fair Work Commission, even if we were to agree to these claims and put them up in a proposed agreement, the Fair Work Commission would have to find that the agreement couldn't pass the better off overall test because you don't know what clauses are going to be agreed by individuals once the agreement is in place. Now, of course, employees can ask for flexible working arrangements. They're a right under the National Employment Standards, and the National Employment Standards are effectively written into the enterprise agreement. So you can ask for them, and you can get them subject to reasonable business grounds, and that includes that fire and rescue is a 24-hour-a-day, 7-day-a-week emergency service that is about emergency response. Now, if there is a disagreement about a decision of an employer to not grant a flexible working arrangement, you can have an arbitration. And the arbitration would take place under Section 65C of the Fair Work Act. Now, what 65C provides in subsection 2A is that the Commission can't make an order that would be inconsistent with a provision of the Act or a term of a Fair Work instrument that immediately before the order is made applies to the employer and the employee. To put that in lay people's terms, a flexible working arrangement cannot, as a matter of law, undermine the effect of the enterprise agreement. It can vary it, but there are confines of it. And the reason why we have Section 65C in the Fair Work Act is because of the experience of the ComSec case I spoke about a moment ago. So even if we were inclined to agree with this, the Fair Work Commission couldn't approve it, and if they did approve it, the agreement would later be open to challenge and it would fall over. That is a nuclear option, which we are not prepared to risk, and for that reason, the claims that I've referred to are opposed. So we've referred earlier to the relationship between these claims that we're now talking about and the claims the employer put forward in 2018. You can see now that there is a strong correlation between them. And as mentioned earlier, we rejected those claims at the time. And you ask yourself where these claims came from. There was in fact a peer review of fire and rescue in 2015, which led to the strategic reform agenda. The strategic reform agenda was rightly considered by firefighters to be hostile. You can see in front of you that these statements from the peer review led to the fire and rescue claims in 2017. to remove the requirement to have appliances and fire stations regulated by the agreement, to have flexibility in rostering, to crew appliances through a risk-based approach, and to remove workers' compensation make-up pay. There is also a similarity between these clauses and advice given by a law firm called Seyfarth Shaw to the CFA. That was to abolish the UFU's influence and to remove any requirement to agree with the UFU. Sounds familiar, doesn't it? And of course, the strategic reform agenda also talked about opening up temporary opportunities and lateral recruitment. And that was pursued as a claim in 2017 that was rejected. When you put all those things together, it's a framework that would allow flexible rostering, removal of Schedule 1 or modifying Schedule 1 would allow the movement of appliances. Put that in the context of the Emergencies Act, which says that the Rural Fire Service can respond when fire and rescue isn't present, and you have a dangerous cocktail which would enable the Rural Fire Service to be put on fire and rescue stations, part-time fire stations implemented, and we would have no industrial leverage over that situation at all. We're not prepared to do that. This union has fought that agenda for 8 years now, and we're not about to stop. We'll leave you to it for now. We note that you don't take a lot of notes in these meetings. We note that you haven't used a computer at all, haven't seen pen hit paper once, and you did want us to record meetings early in the piece. So this recording's especially for you. You can play it as many times as you want, you can take notes, and you will be under no doubt about the reason why we have rejected these claims. Thank you.